for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Those of you guys who ever want to comment, 855 Law Radio, but we got to talk about Weinstein. So we've been following Weinstein for months, and we've been talking about this for months. And this is kind of where the Me Too movement started, was with Harvey Weinstein. And I told you about and I tried to find it on YouTube. I couldn't find it. But remember those roasts they used to have, Dean Martin roasts?
Yes.
So the Dean Martin roasts, they actually were roasting someone, and I believe it was Don Rickles was roasting some people. And he turned down, and he looks down in the audience and says,
That's right.
"Oh yeah, all you young people think you know who you are. You, Mr. Superpower, Mr. Producer, Harvey Weinstein." And it shows him sitting in the front,
Yes.
laughing with young ladies around it near him.
And this was early on in his career
It's
too.
like
He was
70s or
he
early
was
80s.
he was the young buck. So,
Yeah, so there we go. So anyway, the verdict comes back, and the verdict is an interesting one that we want to discuss. So it was basically 5 days of deliberation, and I've heard one lawyer, well-known lawyer, say in the media that definitely goes against the grain, because after 5 days, it's usually a hung jury. The odds of it not being a hung jury are pretty rare. And that's what everyone was thinking. After 5 days, it's going to be a hung jury, because all you need is one that's going to say, you know what, I just don't see it. You know what I mean? And so he's convicted of rape in the third degree and criminal sexual act. And we're going to talk briefly about what that means with Denise and I and Todd, but mainly Todd, because this is his forte. This is but here's some interesting notes. Some first notes. He truly does believe that he's innocent.
Oh, yeah.
I think in fact, they noted that what they saw him saying to his attorney, but I'm innocent. He said it 3 times to his lawyers, just stunned as he sat motionless, saying, I'm innocent. And then he obviously has some chest pains. They put him in cuffs and take him to the hospital. But we're going to talk when we come back about the interesting things of the different areas that he was charged with and how they apply. Rape in the first degree, rape in the third degree, were some of the, and then we had criminal sexual act in the first degree, predatory sexual assault, and then one other. I can't remember. There was one other.
I think there was 2 predatory sexual assaults.
Yes, so we're going to talk about those and go over them with kind of Todd, who that's his what area of law he specializes in. We'll be back. Not specialized, but does.
yes.
Boys are weird. Oh, come on.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penney.
So we have the pleasure of having a number of attorneys. There's 3 of us that sit here. I'm a personal injury lawyer. Denise does family law, but Todd is a former prosecutor for the district attorney's office in Tennessee and in California, and now has his own criminal law practice. Todd, walk us through what these charges are, and they're in New York, and how they apply, or what he was found guilty of and not guilty of.
Sure. Well, he had 5 charges that he was facing. One was rape, one was criminal sexual act, and I mentioned those first because those were the 2 that he was found guilty of. But he also had 3 other counts that he was acquitted of, and the 2 of the most serious charges against him were being a sexual predator. And the jury took 5 days, and what Fred said was correct, that oftentimes attorneys will look at that and think, if the jury is taking 5 days, it really raises the likelihood that they're looking at a hung jury, not able to reach a unanimous verdict on all of the counts. And that's what's required. The jury has to, 12-person jury, it's got to be 12-0 on each count in order to convict. And so the question is, what took so long? And the longer it takes, the higher the likelihood that it would be a split decision and therefore a hung jury. But we don't know which counts it was that the jury hung up on. It could have very well have been, we find him guilty on these, that's the no-brainer, but we still got all 5 counts to deal with. And we don't know if maybe it was a quick acquittal on 2 counts, but now they're really wrestling with the last ones that they convicted on. We just know that the whole thing took that long. So this is really a split in terms of whether or not you can view this as a victory for either side. Because on the one hand, everybody who wanted him deemed a sexual predator, which would result in life imprisonment, he was acquitted on those. He was acquitted on those.
The questions of the jury is kind of dealt more with Sciorra.
That's right.
One of the I always forget the name of that. The special acts, the enhancement.
The prior acts.
The prior
yes.
acts. They asked so many questions about her that it seemed to me that that's where their biggest argument was. They got stuck on the sexual predator claims, and it just seemed like they put a lot of time into that.
So let's go back and talk about that really quickly. The reason the prior acts, now we're talking about allegations that, or evidence that Harvey Weinstein had engaged in prior conduct against certain women, but he was not being charged with those in this case. It was being brought up to show what they call a modus operandi, common plan or scheme. All of that would have been to show he's a predator and this is how he stalks his prey. He did it in the past with this person, with that person, and he did it with this person here, the last person being the one who was who Weinstein was charged for violating, right? And so the questions came about Sciorra and others, because those questions would have gone to whether or not he was a predator or whether or not they were going to limit their decision to the specific act at the specific time. And ultimately, they felt that they could not, on the evidence, determine that he was a predator. Last couple of weeks, we talked about the cross-examination from the defense, and the cross-examination went into impeaching those people, that evidence, about the prior acts. So they won on that. The defense won on that, but they did not win, and the prosecution prevailed on the issue of rape and criminal sexual act without the predatory nature.
Yeah, with his age, it almost doesn't matter.
Exactly.
How many? It depends on what the judge is going to sentence him with.
He's looking at 28 to 30 years.
He could.
Yeah.
And then he's got his prosecution in L.A.
Exactly. I mean, it is not over for him by any stretch of the imagination. Now, after he was convicted, and Fred talked about how he said, I'm innocent. Denise, when we were on the break, you raised an interesting question about why they took him into custody. Because they put the handcuffs on him and took him out. Ultimately took him to the hospital because he had heart palpitations, but they did take him into custody. You remember that question?
Yeah, I found it unusual because it seems like Stone wasn't taken into custody until he was got his sentence, and a lot of people don't go into custody till after the sentence. So how come they took him into custody right after the conviction?
So these things are done on a case-by-case basis, depending on a lot of factors go into it. One is what sort of a sentence is a person looking at afterwards? In Stone's case, the worst he was looking at was 9 years, and obviously on the original sentencing recommendation, and he ended up getting, 30-some-odd months or 40 months. But when you have a defendant like Weinstein, who's looking at close to a maximum penalty of 30 years, and then you consider that he also has other charges he's facing in other jurisdictions. And then you take into consideration his resources, financial resources. There is a very serious concern that the individual might flee. And let's remember that his status changed as soon as the jury said he was guilty. He was no longer presumed innocent of those charges. He was deemed to be guilty. And in those situations, a court will take somebody into custody. Let's remember the Roman Polanski case. He was out of custody, pending sentencing. He fled to France, and this was back in the late 70s when he fled. Roman Polanski has never come back. He's directed films that have won Oscars, for crying out loud, but he's never come back to the United States, to the Los Angeles County jurisdiction, to face sentencing for what he did previously, and that is what they're trying to guard against.
Yeah, Polanski right now is in the news because he's going to get one of the highest awards in France.
He won.
And he won.
Yeah.
And he won't go to France because there's going to be a big crowd, upset with him because he's had other jurisdictions where he's had criminal acts against him brought, and he hasn't gone to those other places either.
Yeah.
So he's kind of a controversial person.
Well, here's another thing here was my take on it. Remember, the DA is a guy named Cyrus Vance Jr. And a DA, everyone think, oh, is that the person prosecuting it? No, he or she is the boss, and they have someone else prosecute it. So the head DA in 2015 refused to prosecute this case in New York for the following reasons. There was no physical or forensic evidence in this case. This was purely a he said, she said credibility case, which the odds of district attorneys usually taking those to court are slim.
And this is in reference to the sexual predator.
Right.
Yes.
And so here's what's interesting about this. He said because of the pressure, it's clearly the pressure to prosecute him made him step up and prosecute him. And the district attorney became a target of protests. And even when he decided to put him on trial, the DA's offices was protested. You know, I kind of, how do I want to say this without being biased one way or the other? And I'm not. That bothers me a little bit. And what bothers me is this, you know, there are a lot of innocent people, I don't know, but there are innocent people put in jail. I'm not saying he's innocent on this one. Don't get me wrong. And I can't remember who was the one that said it better than one person that's guilty go free than multiple ones that are not guilty.
It's better than 100 people guilty go free than one innocent person spend a day in jail.
Or their life in the jail.
Yes,
That's exactly right. And so that scares me a little bit. By pressure, this DA decided to go ahead and I'm not saying...
But that happens all the time. I mean, remember Rodney King and all the riots. Remember,
right.
You know, the society does pressure when they feel there's been an outrageous thing done.
Okay, now let me tell you the difference. Rodney King time and now. What have I always said is the problem right now? Social media.
Oh, social media.
Oh, yeah.
Social media. So you are guilty until proven innocent. And it's so fast, it's so powerful that automatically people say they're guilty or that, and they don't know anything.
Well, the one thing I would point out on that is when you look at the indictment or if you look at a complaint or anything like that, it always says the people of the state, in this case, it would be the people of the state of New York in and for the specific county against Harvey Weinstein. So it's the people that are prosecuting, and who have the people appointed by way of an election to represent the people's interests. And so the people in this case would be saying, if you're not going to do the people's bidding like we want, then we will find somebody else that does. The thing I find interesting in this is Vance didn't want to prosecute because he said the evidence wasn't there. Weinstein was ultimately acquitted of being a sexual predator, so Vance's initial concern was correct. But then Vance comes out and in a statement says Harvey Weinstein is a vicious serial sexual predator who used his power to threaten, rape, and assault, trick women. Well, wait a minute. He was acquitted of that.
We're going to be back, and we're going to talk more about this. I'm going to talk about what defense lawyer Donna Rutano says and why this case may win an appeal. We'll be back.
Radio Law Talk. I like that show.
Radio Law Talk. Now, back to the show.
Yeah, we're back talking about Weinstein case. We're going to finish it up this last segment, but a quote from the defense attorney for Harvey Weinstein is a attorney by the name of Donna Rotuno, who probably now has enough fame that she's going to become well known. And she argued in court. She said that that in the court of public outrage. Okay, she said. She argued in court that the public outrage over Mr. Weinstein's behavior had basically, tagged him as a rapist without due process. And that's her whole thing that she's apparently sticking to.
And I want to point out something on this with regard to this case, because I know that there are probably listeners out there that might be listening to us saying, so what, do you think he didn't do it? You're defending Harvey Weinstein? What's the big deal? I mean, look at this evidence, and he knew what he was doing, and they're saying all of this to us right now. And the reason why I am specifically talking about this is not because of Weinstein specifically. I'm talking about this because if this is a process that is employed and it starts to set the precedent in terms of prosecution to use this against the Harvey Weinsteins of the world who might truly be guilty,
or pigs,
there is nothing that keeps them from employing the same modus operandi, if you will, against somebody that's truly innocent. And that's where it gets to be a problem. It's not that I raise this issue to protect Weinstein. I raise this issue because I'm concerned about the system. And I'm concerned about how this system, if this is used, can be used to convict somebody that is truly not guilty of the crime. And that's my worry.
This started, in my opinion, with the O.J. Simpson trial, where everybody had to be out in front, where everybody was doing a news conference every day, and the whole thing was broadcast live, and people saw this thing play out. They made their own conclusions. How many of you honestly think that O.J. is not guilty? You know, I mean, if you were raising your hands in your car, he may have been found not guilty, but was he really not guilty? Yeah, right? Everybody has their own opinion.
Actually, yeah, I don't know.
I also think there's another time that this really played its hand out, and that is in the case of Ferguson, Missouri, and the police shooting, right? You remember all of this.
Yes.
It was a controversial time. Turns out that what people thought happened had not happened, but everybody got out in front of it. Everybody had their own version of the facts, and it was all over social media before the final report was issued.
And that's the issue, Cal, is social media now has blown it up so much and so fast, our judicial system cannot keep up with it. They can't keep up with it.
And you know, so those are cases that happened before we started doing Radio Law Talk. But you look at stuff that we've covered since Radio Law Talk. Look at the liability, not criminal liability, but civil liability that news outlets have faced because of the whole Nick Sandmann thing.
That's right.
Where they tried to say it was one thing, and then when you actually saw the whole video, it turned out to be something else. And it's this shoot first, ask questions later.
That's why
kind
we
of
have
thing.
Disclaimers.
Yeah. And so it gets to be problematic. If it's problematic on a civil aspect, it's even more so when it comes to a criminal aspect where it's not money that's hanging in the balance. It's somebody's liberty, and they're going to end up spending time in jail. And that's where it's a problem.
But I will also tell you that the news business has changed immensely because of social media. It's no longer, here's your beat, go out and develop contacts. It is, let's react to whatever we see blowing up on social media rather than being responsible journalists. And it has blown up in the media's face so many times that the credibility keeps going down and down and down and down. When will the lesson be learned?
And that's Cal Hunter talking, who's been a newscaster for 20 years, 25 years.
Yeah, it has changed so much.
Yes.
It's not a business I even recognize anymore.
Yeah, it's very different because they fact check, they do all these things now, and it's instantaneous. They can now get it out there into the world. They can tweet, they can,
But a lot of times they don't
Instagram, they could do it, and it doesn't matter if it's true or not. As long as people like the message and they retweet it or use it or touch it, it's going to go, viral. And going viral does not mean it's true.
Yeah, no, that's big to go viral.
And look, you when you ask the question of what's it going to take to stop it, well, I know what is not going to happen. I know that it will not be as a result of governmental intervention. There is no way, even though the government will put restrictions on the Second Amendment and do things, there's no way when it comes to the freedom of the press and freedom of speech that the government is going to come in and try to regulate what a news agency can or cannot say. That will not happen. So the only way that it can is through the lawsuits. If it hurts their pocketbook, then they'll stop doing it.
I think that's key. I'll give you a classic example. There's one local news organization of which I am very aware that will take police scanner traffic and put what they hear, the initial call, police calls, and write up a quick story and plop it out on social media. It's kind of against the law to use the actual transmissions. They don't do that. But not verifying it, not fact-checking it. Well, the cops say they got a body over by the river. Bam, it's up on social media. Turns out it's not a body. It's a homeless guy sleeping underneath a sycamore tree, right?
Yeah.
That doesn't make it out. Just the dead guy.
Right.
Because it's not sensational.
But but the Cal on their side, they have to do that to stay ahead of their competitors.
It's a competitive situation.
It's so competitive now, and it's just crazy, and it's just I just don't know how this country is going to react, both the judicial system and the news media can stay up on this. Call us at 855 Law Radio if you want to call in. But one final thing we want to talk about before the end of the hour. We have to get to this. Sentencing is March 11th. There's two issues that may come forth that may be appealable. The first issue is that the day of the trial started, or the day before, the L.A. The L.A. District Attorney's Office announced that he is going to be prosecuted in Los Angeles after the New York trial. So that could be prejudicial to some degree. But the biggest bomb, Denise, was what? Is why do you think they might win an appeal? There's a juror that. What about this other juror?
Well, this other juror was an author, and she had actually written a book already about an older person who had a relationship with a younger woman, right? So very, very similar to what was going on before her. And it's going to be published coming out this fall.
Right.
And here we are. She wrote this book.
It's called basically about predatory men having relationships with younger women.
That's right. And when I first heard of this, we thought it was because she was reading a book about a teenager having a relationship with their professor. Mm-hmm. You know, kind of this age difference and kind of a different type of a relationship. And I couldn't see the connection. But when I found out she'd actually written a book about sexual predators and you know, very similar to a Hollywood type of a scenario, I could understand why the defense was up in arms about this juror.
Does she have a financial stake, Denise?
Well, yes, she will. She will.
Well, we can't say we don't, but she might.
Well, she may write another book. That's one thing, but we don't know how she actually voted.
That's true.
So we don't know what she did. And Todd, you had said something to me that made me think. I always thought that you could, if you make an argument that something was not fair with the juror, I always thought that the juror got to be taken into chambers and you got to do like a deposition of that juror real quickly. Yes. So that you would find out behind the scenes what really was the truth of this juror.
Like you're talking about during jury selection, or,
no.
or if it came up during trial, you take the juror into?
Yes, during trial, and then after trial, I thought it was the same.
Well, after trial, the jurors are usually advised that, you guys, if you want to, you're free to talk to the defense and the prosecution if you want, but their requests have to come to you at reasonable times, and if you don't want to talk to them, you don't have to. So it's the juror's option. Well, my guess is there's a lot of defense investigators that want to speak with the jurors to find out what happened in the jury room, if this person that we're talking about, the author, played any part of it, maybe how she voted, what happened. I mean, I think it would be interesting if, despite all of this, she was one of the holdouts for not guilty.
On the sexual predator part.
That would be very interesting.
Yes.
So we'll see what happens.
Yeah, the interesting thing about that, though, you have to remember is the defense brought up a motion before they tried to kick her out, and then after they were done. They're done, but the verdict hadn't come back. They tried to remove her, correct?
Yes.
And the judge said no. Cal, we have 30 seconds. Do we have that?
Yeah, 30? We just had a caller call in, said there was an interview on a Dennis Prager show of a couple that sat in and said that it was interesting when the prosecutor made their case, media was all over it. When the defense made their case, not so much. The media does not have an obligation to report both sides. They're going to draw conclusions. That's what the world is now, I'm afraid.
Yeah.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.